Welcome to literary and jury charge practice. Let's get started with some jury charge. And let me just take a quick glance here, see if there are any words that might be a challenge. We have proximate cause. Looks like approximately. All right, let's go ahead and give it a try. Ready? The defendant in the case has been accused of proximately causing the accident. As jurors, you must examine the evidence and determine whether this is the case. You must know the meaning of proximately causing the accident. The meaning of proximately causing the accident is immediately causing the accident. In order for the plaintiff to recover, the defendant must have proximately caused the accident. The issue goes to whether the defendant proximately caused the accident. It could be that the plaintiff proximately caused the accident. You must decide whether this is the case. You must decide whether the defendant was in any way responsible for any portion of the accident. This question is a question that is always considered in the cases of liability. You must decide who is responsible for proximately causing the accident. In liability cases, it is necessary to know who is responsible for causing the accident. The cause of the accident is most important in determining the amount of damages that are due the plaintiff. The plaintiff is able to recover if it can be shown that the plaintiff was not the proximate cause of the accident. You must determine who proximately caused the accident in this case. The defendant has admitted liability for the injury. The question now goes as to the amount of liability that the defendant must sustain. It has been shown that the plaintiff in this case was responsible for a portion of the accident. The plaintiff can be responsible for a portion of the accident. It is now for you, the jury, to decide the amount of liability involved. It is not necessary for the plaintiff to be free from responsibility. The plaintiff may be responsible for some of the accident. You must understand your duty in this regard. The duty of the jury is to determine whether the plaintiff should be able to recover all or part of the damages resulting from the plaintiff's part. You must determine whether the plaintiff is able to recover at all. As indicated, the defendant has admitted liability for a portion of the injury. A defendant may admit some liability. Whether the plaintiff suffered damages as a result of the liability of the defendant is not the only issue to be decided. What must be decided is whether these damages resulted from the defendant being the proximate cause of the accident. All right, now let's do a portion of our article on writing the Republican National Convention. Ready? What were you reporting? How did you handle any unique situations that came up with this assignment? For example, special security, etc. DD. Security. Be early. Have your equipment organized and easy to navigate through security lines. Wear a smile even if the search gets to the point of ridiculous, absurd, and even invasive. And be friendly. Security is definitely an environment where what goes around comes around, and your understanding and compliant attitude go a long way. When you make their job easy, they are much more inclined to help you. ST. The first obstacle was just getting to the building. Streets were blocked, so it was difficult to get to the event location. While we stayed at a nearby hotel, a taxi could only get us so far, and then we had to schlep the equipment the rest of the way. We certainly had to allow ample time to navigate the heavy security requirements just to get there. Once inside the building, Debbie and I were reporting the platform committees. This involved many speakers discussing topics in a fast-paced environment, so it was certainly a challenge keeping track of everyone. It was sometimes hard to see who was speaking. It was also difficult at times to hear clearly due to the room size and mic placement. Each participant had terms, cases, and people they were discussing that were unique to their state, yet at the end of the day there was no opportunity to obtain spellings. It was a heavy research project in order to provide an accurate record. Right, we'll leave that for now. There's a few more questions. And then we have an article called Writing the Democratic National Convention. So we'll get to that one too. So let's get back to some jury charge practice. Okay, ready? Here we go. The judge reminded the jury that they were to act as a prudent person would act in determining the verdict for this case. As prudent people, they were told that if they found that there was not enough evidence to prove that the defendant has committed the crime for which he has been charged, they must move for an acquittal. On the other hand, they were told that they must return a verdict of guilty if, after having examined the exhibits and the testimony of the witnesses, they determined that there was enough evidence for a conviction. It was the testimony of the police officer that caused them to have the most doubt. The judge told them that as jurors, they must find that the defendant was guilty beyond all reasonable doubt, and if they could not find that he was guilty beyond all reasonable doubt, they must acquit him. They had to consider what caused them to have reasonable doubt. They could not find the defendant guilty when they had reasonable doubt. the people had not convinced them beyond all reasonable doubt that the defendant was guilty. They were instructed by the judge to make the decision that any prudent person would make under the circumstances. Since this was a murder case, all the jurors must agree as to the guilt of the person, and all must feel beyond a reasonable doubt that he was guilty. They examined all the exhibits and went over in their minds all the testimonies presented by the various witnesses. Still, the testimony of the police officer was in question. They discussed the fact that his testimony had raised serious questions. In the end, they could not vote in favor of the people. They had to vote to acquit the defendant. They could not find him guilty beyond all reasonable doubt. In criminal cases, the people are considered the plaintiffs. Before a trial, a person charged with a crime is given an opportunity to enter a plea. It is the people, not an individual, who is bringing forth the action. The people are the individuals who are represented by an attorney. Let's get back to our article about writing the Republican National Convention. See what the next question is and what the response is. Ready? How is writing for a political arena different than legal reporting or broadcast captioning? DD. You just never really know what you are walking into. The product you are producing can be different than what you expect. The delivery system isn't always what you are used to. This is also an environment where new and innovative ideas can be formulated. Because you know the capabilities of your system, you are in the best position to look for opportunities to provide things that the client may not even know are possible. As you listen to conversations taking place around you, you can often think of ways they can use what you have to offer that they are unaware of, or something may come to your mind that, if you are skilled at the many features your software provides, you can change parameters to provide valuable resources to your clients in these unique settings. For example, I got done before Sue, so I was in my caucus room while the aides were working on the final documents. They were unable to reach a consensus on what had transpired, and finally, after quite a healthy debate, one aide looked at me and said, "Do you have the ability to tell us what was said?" "Yes, I certainly can." After reading back the pertinent sections, they said, "Can you stay until we are all done?" Immediately, I became an integral part of the team. ST. I've done some other political type work in the past, so I was aware that one of the unique challenges you always face is that many of the people involved are really not familiar with what's necessary on the reporter's part in order to make an accurate record. That means that you have to be able to quickly assess the environment when you walk in the room and be confident enough to speak up to your contact person on the site and tell them politely but succinctly what you need in order to do your job. Time is of the essence for everyone there, so organize your thoughts well, but make sure you have the conditions that best enable you to produce the best product possible. Okay, let's get back to this jury charge. See if we can finish it up. Here we go. In this case, the defendant made a plea of temporary insanity. An attorney appointed by the state is a representative of the state. At the trial, the people bring forth the suit, but it is up to the jury to decide the guilt or innocence of the party who has been charged. The jury will make the decision whether the person is guilty beyond all reasonable doubt. The jury may decide that the individual is innocent beyond all reasonable doubt. When temporary insanity is the plea, the individual is hoping to avoid punishment. The attorneys who represent the state in all criminal cases must present enough evidence to convince the jury of the person's guilt. The defendant must be shown to be guilty beyond all reasonable doubt in the case. If this is the case, the results will be that the defendant is found to be not guilty. In cases where temporary insanity is the plea, a person is saying that he is not guilty by reason of insanity. If the jury is not convinced beyond a reasonable doubt of the defendant's innocence, then the jury must find in favor of the defendant. If that is the case, he will go free. To present the evidence in court, the attorneys that represent both sides will select people to testify at the trial. As one form of evidence, both attorneys will try to find evidence that will convince the jurors of their positions. Evidence presented in court is called testimony. Testimony consists of the words of the witness taken down while the witness is under oath. In addition to testimony as a means of offering evidence to the court, the attorneys may have any number of different types of exhibits to use as proof of their positions. Both sides have a right to as many exhibits as they have to support their sides. During the trial, the witnesses will be called, starting with the witnesses for the state. The state is putting on the case, so the state must prove the case beyond a reasonable doubt. The state first presents one of its witnesses and questions the witness under oath. It is up to the state to prove the case beyond a reasonable doubt. After the state is finished questioning the witness, the other side is given an opportunity to examine the same witness. In examining the witness, the defense attorney will try to reduce the credibility of the witness. When the defense attorney questions the witness, he can ask questions that only have to do with the questions that were brought out by the state. When the state has finished presenting all its witnesses, the defense has an opportunity to call its witnesses. All right, that will conclude our literary and jury charge practice. Thank you.